My Lord, the President of the Nigerian Association of Family Court Judges, Magistrates and Other Practitioners, Honorable Justice Eberechi Suzzette Nyesom-Wike, Executive Council members of the Association, our respected speakers for the day, Professor Iyabode Ogunniran, Family Court Judges, Dr. Yannick van den Brink, distinguished members of the bar and the bench, Executive Council members of the Association, our respected speakers. Distinguished members of the bar and the bench, honorable commissioners here present, academics here present, social welfare officers, including family court assessors, officers of the Nigerian police force, all other respected practitioners of the family court, distinguished ladies and gentlemen. I welcome you all to the maiden edition of the NAFCJMP webinar themed The Protection and Participation of Children in the Justice System. With this webinar, we aim to gain further insight on the Child Rights Framework and its practical application on matters concerning children in contact with the justice system at the different stages. Professor Ogunniran will be addressing this discussion particularly within the scope of child victim survivors, whilst Dr. Yannick's discussion will center primarily on children in conflict with the law. So before we proceed, we have just a few housekeeping rules. And this webinar, as we can see, is being recorded and also streamed on YouTube. You can also see that our microphones are currently on mute, but please feel free to use the chat box for comments and questions as well. And your questions will be answered by both speakers at the end of the second session. So if you have any questions, please do not hesitate to put in the comment section. Also, I just want us to also notice at this juncture that the NAFCJMP is also on social media. So if you also have wonderful insights in the course of this webinar, of which I believe you will, you can always use the hashtag NAFCJMP and also follow the association on its social media handles on X, Facebook, Instagram as well, with the handles NAFCJMP. And we look forward to an amazing webinar this evening. And now, may I, at this juncture, invite the NAFCJMP President, most humbly, Honorable Justice Eberechi Suzzette Nyesom-Wike, for the opening remarks. You are most welcome, my Lord. Thank you.
Good evening, ladies and gentlemen, my lords, my ladies, your worships, the executives and members, and also intended members of the NAFC Jump, distinguished speakers, Professor Iyabode Ogunniran and Dr. Yannick van den Brink. I also welcome the moderator, the friends of this worthy association, and all Nigerian child lovers. Indeed, the moderator has set the precedent as far as protocols is concerned, and I should rely on that. But I should say that I took the liberty to invite some of the Nigerian governor's spouses, many of whom are here, but to respect their preference for privacy, I will mention no names. A very well welcome to your excellencies, and you are all essential stakeholders concerning child's rights, and we feel really honored to have you here. I would like to, before I go any further, state that the judges right now on this platform are on different levels, from the High Court, Federal High Courts, up to the Supreme Court. And we feel really honored to have my lords and my ladies together here with us. A lot depends on us. A huge thanks go especially to these are two distinguished speakers for your willingness to share your thoughts, your time, and your knowledge on the subject of child's rights in respect of the protection and participation of children in the justice system. This topic is really apt, as I believe that never has it been more than now in our consciousness that the issues concerning children have featured prominently. The whole essence of today's engagement can be summarized into two words found in a verse in the book of Proverbs. I realize that on this platform there are many Muslims, just as there are Christians, but I have many times heard that a good Muslim reads the Quran, but an excellent Muslim also reads the Bible. So I take a quote of three words from Proverbs chapter 27, verse 17, that simply states, iron sharpeneth iron, meaning that one person, by engaging and rubbing minds with another, sharpens the other person. And so we are all getting ready to be sharpened on this platform by our speakers and by ourselves as we share our ideas and experiences. So going back to the topic of child's rights, and in particular, the protection and the participation of children in the child justice or in child justice, I will need to refer to the Child Rights Act of 2003 and especially to parts 20, 21, 22, 23, and 24. Therein, the subject of the justice administration for children is set out. I realize that it is impossible really for us to make any significant progress in the child justice system in the absence of the infrastructure that we need to help this process go through smoothly. In part 42, that is section 249, it speaks to approved children's institutions, and there you have different institutions rendering different services or supposed to be rendering different services to children that are in conflict with the law. We have the Child Attendance Center, the Children's Center, the Children Residential Center, Children Correctional Center, Emergency Protection Center, Special Children Correction Center. All of these have their intended uses as stated in that section. And I wonder how many states in Nigeria have these important facilities, and where are they, what do they do, and what condition are they in if they do exist? I'm sure that there are not many states that can say that. And I find this really sad. Some of these institutions are to provide for children that should be daily visiting the center in order to keep them occupied so that they don't find time and space to be, engage in activities that will bring them in conflict with the law. Anything that is mischievous, anything that will make them come against the criminal law. That's what some of these institutions are for. Some are to keep the children there until they finish or go through their trial. Some are also for them to be there because they're in conflict with the law and they're still within the age of being adopted. Of course, they're children, so they're kept there until they can be fostered or adopted. There are those that keep children who have been found to have their, charges or information proved against them, and they need to be there for custodial purposes. And some of them will just go there to learn a skill or the other so that they can be more productive and useful citizens to our country. There are even those, that will be the Special Children's Correctional Center, where you have those children who are more or less a bad influence to all the children that are within the, facility, and they want to put them away because, they have the penchant of always finding themselves on the wrong side of the law. So they keep them in a place where they will not have access to all other children in order to influence them. All these are necessary. We should have safe homes. We should have emergency protection center where a child that needs to be in the custody of the police or in a place where they should be for their own safety should be kept. And I can say without any fear of contradiction that we don't have all of this in Nigeria, which is sad. So if you go to section 149 and section 156 of the Child Rights Act 2003, you will see that there's provision for the establishment of the family court as the court, and it's essentially a children's court to hear and determine matters relating to children, and for these cases to be held in camera or treated on a case-by-case basis, respectively, meaning that children's cases should not be heard where people or members of the public can walk into the court and be experiencing or seeing or noting these children. And the whole essence is to protect them from being labeled or being victims of stigmatization. But you will see that in some instances, especially where we see that there's the court that is called the juvenile court that was birthed by the Children and Young Persons Law in 1958, an act that is older than Nigeria itself. You know, they don't keep to the rules of the family court that is provided for in the Child Rights Act. I'm not saying all of them, but a lot of them do not, because I've experienced this. And it is sad because these children are supposed to be protected. They are supposed to be kept away from anybody that can identify them. In fact, it's only their parents, their legal representatives, the prosecutor of state counsel who will do the prosecution, the court staff, the assessors, the judex itself or herself, himself, and anybody who has direct, how will I say now, a reason to be there in court. So they're not supposed to be out there for people to notice them and hold them to account maybe sometime later in their years. And because they're children, they can change. They can get better. And it is what we put in them and what we give them as caregivers, as parents, as people working under the law and looking after them in different way and encountering them. What it is that we put in them is what they will give back to society. Section 205 of the Child Rights Act is very clear. Children are not supposed to be noted when they come in conflict with the law. They're not supposed to be noticed by members of the public. They're supposed to be shielded. Even when they give their testimony in court, they're supposed to be in a place where nobody can see them. You can hear them, but you shouldn't be able to see them. So there's a lot that we need to do in Nigeria to make sure that our child justice system gets better. A worse situation is where the juvenile court runs and coexists side by side with the family court that was created under the 2003 Act. Both statutes are different and essentially seek different outcomes in relation to child justice, while the Children and Young Persons Act and laws seek to punish the offender, the child offender. The other and later statute, which is the Child Rights Act, looks for a way to reorientate, to rehabilitate and reintegrate the child into society. In other words, punishment is not the target. They think of reforming the child. It is reformative and it operates in the best interest of the child. That's the principle that runs through the whole of the Child Rights Act for every child in every situation. This is why the Judex sits with assessors who bring their skills and experience to bear in the process. While the Child Rights Act sets the age of maturity at 18 years, the Children and Young Persons Act and laws states that a child is one under the age of 14 years old, while a young person is one between 14 and 17 years old. This is a discrepancy in the age of the child, and it is significant when it comes to criminal, contractual, and tortious responsibilities and culpability of the child, amongst others. And the consequences at the end of a trial, whether civil or criminal, are different, especially in view of diversion, which accords with the best interest of the child, that should be of the paramount consideration in every circumstance. This principle is absent in the the Children and Young Persons Law and Act, causing double standards in the treatment of children that appear before courts in the same state, for example. Section 162 sub 1 provides, and I quote here, no other court except the family court shall exercise jurisdiction in any matter relating to children as are specified in this law, of course. Yet, still, the juvenile courts in some courts still operate contemporaneously with the family court, resulting to a duplication of efforts and undue waste of judicial resources, since the Child Rights Act 2003 is an upgrade of the Children and Young Persons Act. It has been noted that in some instances, the magistrates in the juvenile courts refer to and apply the provisions of the Child Rights Act, which to my mind shows the deficiency in the Children and Young Persons Act and laws and makes nonsense of the coexistence of both courts. As we may know, the Child Rights Act 2003 is a conglomeration of the African Charter on the Rights and Welfare of the Child, 1990, and the United Nations Convention on the Rights of the Child of 1989. Section 151 sub 1 of the Child Rights Act sets out the general jurisdiction of the family court and provides that the court shall have unlimited jurisdiction to hear and determine any civil proceedings in which the existence or extent of a legal right, power, duty, liability, privilege, interest, obligation, or claim in respect of a child is an issue, and B, any criminal proceeding involving or relating to any penalty, forfeiture, punishment, or other liabilities in respect of an offense committed by a child against the child or against the interest of a child. Considering this provision that covers any cause of action that may accrue to a child, what will be the justification for the continued operation of the juvenile courts? It is suggested that they be done away with, and thankfully, there is an ongoing review of the Child Rights Act and the child justice system that is long overdue, as that legislation is well over 20 years and needs to be brought to par with present day realities. I'm a really firm proponent of the position that laws that have stayed for an amount of time should be reviewed from time to time, because things change, customs change, cultures also change, people change, and it's something that we should keep reviewing. There should always be a review of our laws to bring them to speed with what is occurring in the society at every point in time. So it is my suggestion that there should be a repeal and a reenactment of the 2023 Act, and it should clearly annul every other legislation concerning children in Nigeria. At one time, it was considered that family and child law is or was a soft law. And this is for the simple reason that it is made from conventions that really are not binding, even if the state parties, ratify them or domesticate them in their own legal systems. But the moment a convention is domesticated and the law is made that accords with the decisions or the resolutions or the results of the convention, it becomes a law right there in that country that domesticates it or puts it in the form of an act or a law. So that means that that law is binding to the country, and then of course if the states therein domesticate them, it means also that they're binding. So when you look at children and really see, indeed, as we are always told, that they're the future, and you realize that right here where we are sitting, our children will take the place, and I'm talking about all Nigerian children, will take our places and by the grace of God, do even better than we can possibly do now. You should see that there is power in looking after our children and in helping them, especially when they're in conflict with the law, because every child can be better. The persons attending this webinar include members of NAFC Jump. I prefer to call it that because NAFC JMP is a whole mouthful. NAFC Jump, I think it's easier for me to, pronounce that. It's a lot of letters. NAFC Jump, the NBA feeder, Aula, staff of the Family Court, Nigeria Police, staff of the Ministries of Social Welfare, Rehabilitation, Women and Youth Affairs, and representatives of members of NGOs who have interests in children in all the different states in Nigeria. I am sure that we should be greatly enriched with the knowledge and experience that we will be sharing, coming from the two distinguished but related perspectives. Because it is our maiden outing, I implore you all to be patient with us and forgive any noted glitches. We will get better with time, I assure you, by the grace of God. And so again, I welcome every one of us to the maiden webinar with a promise that this experience will be enjoyed once every quarter in order for us to all rub minds together, share and get resolutions to any challenges we may encounter in our work, and also acquire knowledge and learning that is continuous so that we are more efficient in rendering the service we are engaged in to enhance the welfare of our children that we encounter and interface with. Personally, I am really excited to learn something new, something different that will aid my work as a family court judge. I believe I can say the same for all judges, magistrates, and other practitioners of the family court, and especially all lovers of children participating in this webinar. And so I will cede the floor to Chisom to take it away, but not before we recite our Child's Rights Pledge to remind us all of our solemn duty to our target interests, which are the Nigerian child or children. There is nothing that is too much for us to undertake in the best interest of the child. And because we are all child's rights advocates in our own rights, I implore us all to recite the pledge, and I'm hoping, Chisom, that you have it up there. Can we see it, please? And I don't understand why I can't even see my picture. Are you hiding me? I've enabled my camera. You can see me. I don't see myself.
We can see you. We can see you.
All right. So I imagine because I did see myself on the screen. It's good. Thank you. I hear you all. So I implore us. Thank you. If we can all recite the pledge, and we must take it to be a prayer, because that is what it is indeed. And we should use it as a constant reminder of our duties to the Nigerian child. And this we shall recite with our palms over our hearts, the left side of it.
To defend the sanctity of their innocence.
Let's start together. Can we start together, please, so we move together?
I pledge to
1, 2,
honor and protect the rights of children,
honor the rights of
protect the rights of
guidance,
divine
guidance,
and love of my duty to every child, to them from public harm, private abuse, the sanctity of their innocence, a role model worthy to lead their conflict right center, to live in child behind.
Child behind. So help me God.
Help me God. Thank you.
Sorry, Elijah. And the link next time.
Chisom, please continue.
Thank you. Milord, the President of the Nigerian Association of Family Court Judges, Magistrates and Other Practitioners, Honorable Justice Eberechi Suzzette Nyesom-Wike, for that insightful opening remark. Indeed, iron sharpeneth iron, and I believe that this webinar will truly aid in the advancement and protection of children's rights in Nigeria as well as beyond. So moving on, we will be taking the first session at this point. And to take us in the first session, may I briefly introduce to us the first speaker. Professor Ogunniran is a legal practitioner, and I would not fail to mention her full name. In fact, Professor Iyabode Ogunniran is a legal practitioner and academic with over 30 years post-call experience. She joined the Faculty of Law, University of Lagos in 2003 and is a pioneer lecturer of child law at the university. And as consultant on child law, she has also undertaken key research roles, including in the areas of sexual and gender-based violence, child trafficking, child labor, and child justice administration, amongst others. Professor Iyabode was one of the UNICEF consultants on child protection and child justice reforms in Nigeria, and also a reviewer of the ECOWAS draft policy on sexual harassment. Also, Professor Ogunniran is also a member of the Child Rights Implementation Committee in Lagos State, and amongst others, she was also a visiting scholar at the Center for Child Law, University of Pretoria, South Africa, and research fellow at the School of Law, University of Reading in the United Kingdom. Professor Iyabode has published widely on matters concerning children and the law, and we are truly delighted to have her this evening as one of the speakers on this highly engaging and informative webinar. You are most welcome, Professor Iyabode. Welcome you, ma'am.
Okay, thank you very much, Chisom. Can you hear me?
Yes, ma'am, we can.
Okay, good evening. Thank you. Okay, do you want me to go ahead?
Yes, please, ma'am. You may proceed.
Okay.
Thank you.
Okay. Good evening to the president of the, is a long word, Nigerian Association of Family Court Judges, Magistrates and Other Practitioners, Honorable Justice Eberechi Nyesom-Wike. I would also like to greet my co-presenter, my co-speaker, Dr. Yannick, the moderator, and all the distinguished participants that we have here this evening. Like Chisom has introduced me, I'm Professor Iyabode Ogunniran. I would like to go to the title of my presentation, which is Protection and Participation of Children in the Justice System. So the outline is, don't mind me because I'm a teacher, you know, you have to lay the foundation. I'll look at meaning, background to the CRC, that is the Convention on the Rights of the Child, the convention, clarification. Then I'll look at the specialized, legislation, specialized institution, specialized procedure that, we are talking about today. And I will quickly say that I'm very happy that we are talking about children today, because about 2007, when I started my PhD, it was like, what are you really writing on children? But every time I go out today, whether as a researcher or to present, I'm always happy that we are here today. So having said that, I will say that at times when we are talking about children, we all assume that we know some of these definitions because they are children. But I would like to contextualize today's paper and say that when we are talking about child protection in child law, we are really talking about interventions that we can use to prevent and respond to risk by children. Maybe the structure, maybe the procedure that we can use to respond to abuse, to violence, to exploitation. When we are talking about participation, child participation, we're talking about the fact that in any proceeding or at any time, anytime we have children, they should be able to express their views freely in all matters. And then after expressing it, we should wait, we should listen to them. Then the justice system, as I'll be talking, you will see that the child justice system is actually different, from the criminal justice system. And that's what I'll be talking about throughout the paper. So briefly, there is a background to the adoption of the Convention on the Rights of the Child, which really, inform the the child-oriented justice that we're talking about today. So we all know about the Universal Declaration of Human Rights that is talking about universality of rights, inalienable of rights, dignity of the human person, the International Covenant on Civil and Political Rights, some declarations, 1924 and 1959 declarations that were made about children just to protect children. But what is important about this slide is that we have some rules, the Beijing rules, the Havana rules, the Yadi rules, and it's a combination of these rules that were composed or compressed into the Convention on the Rights of the Child that we have today. And the reason why I had to mention it is that at times I'll be referring to the, Beijing rules. So we have the Convention on the Rights of the Child, and people will be asking, what is so important? Why should we want to be part of the domestication of Convention on the Rights of the Child? Is because if you look at the history of Nigeria, you will see that legislations protecting children, just like the Honorable Justice said, they are just scattered across different legislations. You have the Penal Code criminalizing sexual offenses, the Criminal Code. You have the Constitution protecting, Chapter 4 on the rights of Nigerian citizens. But most of these legislations, they are adult interpreted before the Convention on the Rights. They are just adult interpreted, and researches across the nation show that our children were not being protected in the criminal justice and in every other area. So we have the convention, which was adopted in 1989 across the world. Nigeria also ratified. I will not go to the problem of domestication and how it was enacted as a Child Rights Act for the Federal Capital Territory, and states started adopting it. Today, all the states have adopted the Child Rights Act. What is the importance of this convention is that for the first time, we have a legally binding document, so to say, that provide comprehensively for the rights of children. And we also have the African variant with the African Charter on the Rights and the Welfare of the Child, which Nigeria has also signed and ratified. to take care of the African peculiarity in terms of harmful cultural practices and the apartheid. So today, I'll be talking about, we know what child protection is now, we know what child participation is, and we know that the child justice system is different from the criminal justice, the adult criminal justice system. We still need to make further clarifications so that we won't be giving, some of these words their ordinary meaning. A child is somebody, any person who is below the age of 18 years. And when we are talking about children in conflict with the law, we are talking about children who are suspects or who are defendants. And when we are talking about children in contact with the law, we are talking about children who are suspected or accused of committing an offense, or children who are victims or witnesses of a criminal offense. I will also briefly mention, because we're doing like a form of training today, the concept of vulnerability. Of course, we are all vulnerable. We are all vulnerable to some harm, and we need protection. But when we are talking about children, they are especially vulnerable because of their physical body. They are very young, their social skills. Just like Leti J said, that children, they are very, very vulnerable. And they don't have defenses. They can't even formulate their defenses easily. And therefore, the society, should protect them. So there is the concept of vulnerability when we are looking at our children because of their evolving capacity. Then the best interest of the child, just like the Honorable Justice said, is one of the guiding principles that runs through the whole gamut of child law and child justice and children's rights. I remember that in our university day, when you talk about the best interest, you are talking about family court in custody issues, who is going to maintain the child or the children. But today, when we are talking about about best interest, we are looking at the basic interest, the entire interest of the child, the intellectual of the development of the child, the physical development of the child, everything that pertains to the child. And the best interest is what is even used under international law today to assess state responses. So, like I said, the child law that we are talking about today, child protection, child participation in the justice system. Due to the Child Rights Act that we have enacted, we now have a child justice legislation. The whole chapter 20 is on child justice legislation. And it's saying that due to the physical, psychological, emotional needs of the child, the justice that should be available to them should be different from the child. Then, in those days, the theoretical underpinning of punishment, you have retribution and deterrence. But now we are talking about reintegration. Let us restore, let us reintegrate the child to the society so that the child can assume constructive role in the society. So we have a child-specific legislation. We have a child-oriented legislation. So also, under this child protection and child participation that we're talking about in the justice system, with the enactment of the Child Rights Act, we have specialized institutions. The police, it says that the police, which is responsible for prevention, apprehension, should be what? There should be a specialized unit as police so that they will frequently and exclusively deal with children. If you look at Nigeria today, I know that Lagos and Abuja, they have the family support unit. Lagos also has the juvenile welfare section in Alakara and Eberechi. We also have gender units, which is not actually bad in itself. It's just that it's just for maybe child sexual abuse. But the Child Rights Act is talking about having a specialized institution, which will be the a children police unit. Related to this is also training. It's talking about training for these officers. But in my own research across the country, what I've seen is that you have trainings that, just trainings like that most of the time they don't even talk about the child rights law. I remember the one training that we had in Ogun State at that time. The first day it was okay, but by the following day, the policemen told us that they've just received a signal and they are all going to their respective posts. So, but in this kind of justice system that we're talking about, they need training. So we also talked about specialized procedure. The child rights says that they should use discretion most of the time, that they can use discretion, the police can use discretion. And when we are talking about discretion, we are saying that you can use your reason judgment. You have a sphere of autonomy where you can reason, but then there should be checks and balances. It talks about diversion, that the children can be even diverted right from the police station upon listening to them. If it's a trivial allegation, or if it is a kind of stealing, probably there can be restitution and compensation. It also talks about rights of children. Of course, you can say that these rights are in the Constitution, but under the child rights law, there should be rights to legal representation, which is very, very important, and presumption of innocence. It also talks about detention, which should be a measure of last resort. But despite the fact that the Child Rights Act has been adopted by all the states in the federation or in the country, if you go to the police stations, you will still see that many of these children are still in custody, which is against the tenets of the Child Rights Act. Then we come to family court, specialized institution. Why do we need family court? Is because of the philosophy underpinning family court, which is therapeutic jurisprudence. It's talking about a court that can heal, a court that can listen to the legal problems as well as the social and personal problems. And that is why family courts are very, very important. In the family courts, the court will always look at the best interest of the child. It will always look at the fact that the child can express himself or herself, and the court will listen, and the court will be able to make informed judgment as a result of it. It's talking about the child-friendly justice atmosphere, where the judge is not even putting on, the wig and the gown that can intimidate the child. And it's talking about privacy of the children. Discretion is also important in the family court. And commentary to the Beijing rule says that when you're talking about discretion, so that it will not, it can be controlled, there should be formulation of specific guidelines on the exercise of discretion. The court can also use diversion, that is, divert the children from the formal justice system. First, it will not waste the time of the court. Secondly, these children there won't be stigmatization of even going through the entire, justice system. But the Committee on the Rights of the Child general comment says that you should only use diversion where there's compelling evidence, the child has, admitted, and there is consent, and that will just close the case. I'm aware that I know that Lagos State Ministry of Youth and Social Development, in collaboration with UNICEF, have a diversionary program. So adjudication in family courts, you have assessors who are social welfare officers, specialized people. They also conduct social inquiry so that the court will be able to make up its mind on the cases involving these children when you're talking about child offenders. But when you are talking about children being witnesses, I have looked at what we have, that is the Witness Protection and Management Act 2022, and is basically protection for those who are accused of terrorism or economic and financial crimes. And that is why I'm saying that today, states should look at whether they also want to amend their administration of criminal justice law, just like Lagos State. In Lagos State, the child can use, the court can even decide that these children, as offenders or as witnesses, that they need protection. So they can use closed circuits, they can give video link, they can also use pseudonyms. I suggest that other states should look at, this provision. Legal rights, fair hearing, privacy, just like the Honorable Justice said. You can't publish the proceedings. The newspaper, a journalist cannot come in. Participatory rights, the child should be able to talk, in the proceedings and hear their views, and the court will listen. Then, guiding rule, at every point in time, the judge will be looking at welfare of this child and the justice system. Welfare of this child and the justice system. So I also want to look at family court and specialized procedure. And it is because we also have child victims, in the justice system. In terms of child abuse, violence against children, most of the time, you have culture of silence. And I want to say that Lagos State have been following what they are doing in terms of adjudicating on child abuse cases, violence against children, defilement, sexual assault by penetration. And I've been seeing some things that, I also want the participants to also think of doing, in their own respective jurisdictions and courts. Like the case of Lagos State and Olufemi Olaleye. This was a case that the defendant was charged with defilement and sexual assault by penetration of a girl that was 16 years old. And it was the court sentenced him to life imprisonment after the case, and his name was also to be put in the sex offender register. But what I saw about that case is the specialized, specialized institution that we have that has really helped. The office of the DPP, very vibrant. They took the case, they looked at the case, they were in court all the time. The prosecutor were well trained. There was even one from the gender unit. There is a child forensic expert from Seseyera. There is a medical doctor from LASUT, and this trial was just within a year. I think that for child protection to be meaningful, different states should start to look at how their institution can work so that these children will be protected when they have to come to court. Within 1 year, the case was finished. The case was concluded. Is a good learning point. And so many other cases, not just this case. Not just this case, so many cases in Lagos State that you have this kind of specialized institution working and giving judgment available. So when we are still talking about specialized procedure, there's restriction on corporal punishment, custodial disposition, no torture or degrading treatment, and then the children correctional centers should be for training and treatment. I know that if you go to many states in Nigeria, number one, there are no children correctional centers. Apart from Lagos State, I know that because I just finished research on their correctional centers. And recently, I think about 2 years ago, UNICEF had to go and release with the Federal Ministry of Justice. They had to go and release some children at the Boston Institution in Ilorin. So I also want to emphasize that in this child-oriented justice that we're talking about, we are looking at non-custodial disposition measures. This is what we are saying that the court should be using most of the time. Because if you go to our institutions or our correctional centers, the facility for training and treatment are not really there. So if they are not there, then in line with the child-oriented justice that we're talking about today, the court should start to use more of non-custodial disposition measures. And I will tell you that it will work. Like the research that we just finished conducting at the Lagos State Correctional Centers, most of these children committed property offenses and status offenses, running away from home, being stubborn, and the disposition mention of group counseling and community service can take care of it. So I'm saying that the non-custodial disposition measures that we have in the Child Rights Act can actually take care of many of these offenses if we look at how we can implement it. I know my time is there. So I will go to the general challenges that we have with the child justice system in Nigeria. Just like what we have, if you look at the Convention on the Rights of the Child, you will see that it's an international document, but they also have the problem of different countries adopting with different backgrounds and different countries with their different resources. So in Nigeria, we have diverse social and economic factors. We have cultural factors. I remembered at a time when we went to do training for some group of people, practitioners in Kaduna State. And I was cautioned that there are some words, though, that you have to be saying, you have to talk like this. I said, if we are going to come in to train them, should we also not be able to say the right things? So cultural factors will determine the extent of implementation, even in most states. Then some states, we have conflict reading states that many of the children are even in IDP camps. And you wonder how you are going to implement. What about inadequate resources? So there will always be need for the political will before this law will actually work. So we had the Nigerian report to the Committee on the Rights of the Child in 2010. 2010, that was 14 years ago. And they noted that Nigeria is still using death penalty, the age of criminal responsibility. You have variations in the criminal code, in the penal code, in the child rights law of different states. Some children are still in police custody, and you don't have coordination. And I remembered about 2 days ago, UNICEF was still lamenting that up to today, Nigeria has not furnished the committee with an updated, report. Then Nigerian report to the African Committee on the Rights and Welfare of the Child in 2012 on children in conflict with the law. The committee noted that many of these children are kept in prisons. Then there is a national survey on violence against children that says that 1 in 4 girls and 1 in 10 boys in Nigeria experience sexual violence. Another problem is lack of data for evidence-based intervention. So even if you want to act, you want to do anything, most of the time, you don't have data that can guide you. So against that backdrop, I'll be making these suggestions today. The first one is training. And I think what we are doing today is also training. Training of the police, continuous training of the police, of the courts, social welfare officers, lawyers, because this is a specialized area. Most of the time, we just assume that because they are children, then we all have an idea. But it's a specialized area. It's a new pedagogy entirely. So we need training. And I would suggest that the MBA, Institute on Continuing Legal Education, should also try to introduce a curriculum on children's rights, on training on children's rights and child justice. Then there should be a review of the police college curriculum. Most of the time, some of the researches that I have done up till now, the police college, they have their curriculum. You have the criminal code and the penal code and some legislation, police act and so on. But the Child Rights Act is not in that curriculum. And what will happen? Right from the beginning, at least everybody, all the police officers should have an idea. They should have knowledge. They should have information. But because this is not there, you just see it's only those who are in the maybe gender units or those who are in the family support units. And most of the time, when they are posted, it becomes a challenge. Then like I have said, the child-oriented justice that we're talking about, we should use more of non-custodial measures like counseling, restorative justice, and community service. Another thing is that the evidence-based violence, when we are talking about evidence-based, when you are talking about sexual violence, most of the time when you want to prevent, you need prevention strategy. There should be training on trauma-informed counseling to actually meet the needs of such children for child protection. Then I know about the revised National Plan of Action on the CRC and the CRA 2009 to 2015 by the Federal Ministry of Justice, where you have provisions on prevention by going to schools and community, specialized officers. And but today, that's almost 10 years. We don't, there is need for a revised national plan of action. And finally, I will talk about child budgeting. There is nothing that we can say today if we don't have resources, if the states are not, earmarking resources for this area of the law. It will just be like, it's there is nothing that we can do. So child budgeting is very, very essential to move for child protection, for child participation in the child justice system. I want to thank everybody for listening to me. Thank you very much.
Thank you, Professor Ogunniran. Thank you very much for that highly insightful session. Through your session, indeed, you have laid down key components as well on the provisions of the Child Rights Act, and also gone on to even provide recommendations, which I believe that by the composition of members in this webinar today, and also members of the association, I believe that these recommendations will be taken from paper and into action. Thank you very much once again, Professor Ogunniran. And to the participants, once again, if you have questions, please do not hesitate to write them down in the comment section, and they will be responded to at the end of the second session. So moving on to the second session, may I briefly introduce Dr. Yannick van den Brink at this point as well. Okay. So trying to. Thank you once again, Professor Ogunniran. Thank you. Okay, so introducing Dr. Yannick at this point. Dr. Yannick van den Brink is Associate Professor of Criminal Law and Deputy Head of the Department of Criminal Law at Vrije University, Amsterdam, in the Netherlands. He is also a visiting scholar at the University of Cambridge, Institute of Criminology in the United Kingdom, and a research fellow at the Netherlands Institute for the Study of Crime and Law Enforcement. Dr. Yannick publishes and teaches widely on themes related to youth justice, criminal justice, criminology, children's rights, and human rights. And in addition to his academic work, Dr. Yannick van den Brink serves as Deputy Judge in the Youth Court of the District Court of The Hague. You are most welcome, Dr. Yannick, for the second session. Thank you.
So I'll try to share my screen. Is it visible for everyone?
Yes, it is.
Wonderful. Well, good evening, everyone. I would like to start by thanking the president of the association and the organizers for the invitation to speak at this webinar. It's an honor. I would also like to thank the first speaker, Professor Iyabode, for sharing her insights. And I would like to thank all the participants for taking the time to be here today. In my talk, I will focus on justice system responses to offending by children, and I will do so from an international children's rights perspective. I will start my talk with a brief introduction to the topic, followed by an overview of international children's rights standards on youth justice. And in doing so, I will distinguish 4 core pillars of a children's rights compliant youth justice system. And finally, I will zoom in on a specific focus area, which is diversion. Throughout my talk, I will give cross-national examples and reflections based on experiences from my own country, the Netherlands, or from jurisdictions where I have conducted research, England and Wales, and the United States. Before I start with the substance, I would like to clarify the aim of my talk. Because first of all, different from the first speaker, I'm not an expert in Nigerian youth justice systems. You, the participating justices, judges, magistrates, other practitioners, academics, you are the experts who work in these systems on a daily basis and have knowledge of local cultures, traditions, and realities. Therefore, my aim is not at all to tell you if and how Nigerian youth justice system practices should be changed. And that's up to you to discuss and reflect on. What I will try to do is present key international standards, combined with examples from the Netherlands and other systems, which hopefully sparks and informs reflections among the participants about your own system and practices. Because in my personal experience, that's the added value of cross-national exchanges of experiences with youth justice colleagues from across the globe, like in this webinar. By learning about other systems, we learn to look differently at our own system. And I've learned myself that inspiration may sometimes come from unexpected aspects of a foreign system. As David Nelkin eloquently states in the context of comparative research, the best practice for us to learn from may not always be best practice as such, but rather that which stretches our imagination about what is possible. Moving a little nearer to what we otherwise never normally think of doing, maybe just what is needed. So hopefully my talk will give some food for thought and discussion, like the presentation of the first speaker did for me. The starting point of my talk is that youth justice is a children's rights issue. As mentioned, the almost universally ratified UN Convention on the Rights of the Child contains specific provisions that aim to regulate the administration of youth justice, Article 40, and to protect children from excessive punishment and from an overuse of deprivation of liberty, Article 37. In 2019, the UN Committee on the Rights of the Child issued a new general comment, number 24, on children's rights in the child justice system, in which it provides an elaborate commentary to Articles 40 and 37, and in which it outlines what a children's rights compliant child justice system might look like. Well, as mentioned, the UNCRC is a legally binding treaty for states parties, including Nigeria and also the Netherlands. The general comments of the committee are as such not legally binding and have the status of recommendations. However, since the committee has its legal basis in the convention, all states parties who ratify the convention have the legal duty to take the committee seriously. Overall, general comments, like general comment number 24, should be seen as authoritative interpretations of legally binding provisions of the CRC, which provide guidance to states as to how the convention should be implemented. If we look at the CRC and general comment number 24, we can identify that a children's rights compliant youth justice system is essentially built on 4 core assumptions: humane treatment of children, child-specific treatment of children, fair treatment, and treatment aimed at reintegration into society. The first pillar is humane treatment. Children in conflict with the law are human beings with human rights who should be treated with humanity and respect for their inherent dignity and worth. And this is also true when children are deprived of liberty. So detention of children in unsafe, overcrowded prisons together with adults, for example, is not in line with this principle. Moreover, torture or other cruel, inhuman, or degrading treatment or punishment is explicitly prohibited under Article 37A of the Convention. According to the committee, corporal punishment of children as a sanction is a violation of this provision. Furthermore, Article 37A prohibits the death penalty and life imprisonment without parole as sentences for children. In fact, the committee strongly recommends that states parties abolish all forms of life imprisonment, including indeterminate sentences, for all offenses committed by persons below the age of 18. In my own country, the Netherlands, the death penalty and corporal punishment are abolished for all people in the criminal justice system, children and adults, since 1870, so 150 years ago. Life imprisonment for children, however, was banned by law only 15 years ago, based on the CRC. And besides, indeterminate close treatment orders for children are still being used in Dutch youth justice, which is not in line with the convention. A second pillar is child-specific treatment. Children, as mentioned, fundamentally differ from adults and should be treated accordingly. Under this CRC, children in youth justice are perceived as lesser accountable, which implies that there should be an appropriate minimum age below which children cannot be held criminally accountable at all, but also that sentences for children above the minimum age are less severe compared to sentences for adults. Children are also perceived as vulnerable, as mentioned by the first speaker as well, and in need of additional protection against harm, which calls, for example, for support of the child by parents or social workers throughout the procedure. Children are also seen as still in development, meaning that youth justice interventions should aim to have a positive impact on the child's development and take into account the child's educational needs, for example. Finally, children are seen as rights holders with own views and voices, which should be enabled to participate effectively throughout the procedure. Against this background, Article 40, paragraph 3 dictates that states establish a child-specific youth justice system which enables responses to offending by children which are appropriate to their age, needs, and evolving capacities. This includes an appropriate minimum age and an upper age limit. The importance of child-specific treatment finds support in developmental psychological insights and brain science. Researchers, mainly from the US, found that children below 16 are cognitively and intellectually still underdeveloped compared to adults. Children aged 16 or 17 are cognitively and intellectually comparable to adults, but lack mature psychosocial skills. They're more impulsive, incompetent to foresee long-term consequences of their actions, susceptible to external social influences, and incompetent to truly appreciate the significance of rights. On the one hand, these characteristics make them more susceptible to committing offenses. And they're more impulsive, incompetent to foresee the long-term consequences of their actions, susceptible to peer pressure. And this is also reflected in the well-known age crime curve in criminology, which usually peaks in adolescence. On the other hand, these characteristics make 16 and 17-year-olds particularly vulnerable in criminal justice procedures. Can you imagine a 16-year-old suspect being interviewed by a police officer who promises to release the young suspect if he confesses? This 16-year-old, being impulsive, focused on being sent home as soon as possible, not overseeing the long-term consequences of a confession, susceptible to the pressure of the authority figure, and incompetent to truly appreciate the significance of the right to silence, for example, might confess even if he's actually innocent. This underscores the importance of taking into account the child's developmental stage in criminal proceedings. And in this regard, it's relevant to note that research even suggests that the adolescent brain keeps developing until the age of 25. Against this backdrop, the CRC demands states to establish a minimum age, which refers to the age at the time of the offense. The committee identifies that several states apply two minimum age limits, for example, 7 and 14, with a presumption that it's up to the court to determine whether the child between those ages is mature enough to carry criminal responsibility. The committee observes that although there is some support for the idea of individualized assessment of criminal responsibility, this practice leaves much to the discretion of the courts, which runs the risk of resulting in arbitrary practices and the risk of very young children being criminally charged and convicted. Therefore, the committee urges states to set one appropriate minimum age, not two. The convention itself does not provide an actual minimum age of criminal responsibility. The committee, however, does provide guidance. Under the old General Comment number 10 from 2007, the committee stated that the minimum age should not be lower than 12 and preferably higher. In its new General Comment 24, the committee shifted its position and recommended that the minimum age should not be lower than 14. And this shift is motivated by new child developmental insights and by the observation that 14 is the most frequently used minimum age worldwide, as reflected in this overview developed by the Child Rights International Network. Still, many jurisdictions have a low minimum age of criminal responsibility. And I believe this also includes Nigeria, but this also includes my own country, the Netherlands, where the minimum age is 12. But also England and Wales, where the minimum age is 10. And this is a stark contrast with, for example, the Scandinavian countries, Norway and Sweden, where the minimum age of criminal responsibility is 15. A child-specific youth justice system also calls for an upper age limit, which should not be lower than 18. Under Article 1 of the Convention, all persons under the age of 18 should be considered children, and according to the committee, no children, so below 18, should be tried or sentenced in the adult criminal justice system. But what about young adults whose brains are still in development, according to recent insights from brain research? The committee welcomes states applying youth justice to young adults, as long as this does not harm the position of children below 18 in the youth justice system, for example, in custody. In the Netherlands, the law allows 16 and 17-year-olds to be sentenced as adults, which is a violation of the CRC. On the other hand, Dutch law also allows 18 to 23-year-olds to be sentenced as youth, which is quite unique and progressive in Europe and beyond. A third key pillar is fair treatment. Under the CRC, children in conflict with the law are rights holders who are entitled to a fair procedure. Article 40, paragraph 2 explicitly grants children with a range of fair trial rights. And importantly, these rights are applicable at all stages of the proceedings, from the first police interrogation until the sentencing hearing. Well, due to time constraints, I'm not going to address all these due process rights one by one in this talk, but instead I would like to highlight two important ones: the right to effective participation and the right to privacy. Effective participation of the child throughout his or her youth justice procedure is a fundamental requirement for a fair trial. To enable this, the child has the right to receive understandable information about the charges against him or her and about the procedure. The child has the right to legal or other appropriate assistance throughout the procedure, and the child has the right to be heard or to remain silent if that's the chosen defense strategy. Overall, effective participation of children requires child-friendly procedures, which include, according to the committee, the use of child-friendly language at all stages, child-friendly layouts of interview spaces and courts, practitioners who are trained to work with children, support by appropriate adults, and the adaptation of proceedings, including accommodation for children with disabilities. And I've seen an interesting example of the latter in a London youth court in the UK, where there was a pilot with speech and language therapists assisting children during their court hearing. Overall, the notion of effective participation is firmly grounded in the CRC, as it connects to the general right of the child to be heard under Article 12, but also to the right to a fair trial and the right to a child-specific procedure. Safeguarding the child's right to privacy is also a key in youth justice procedures, and this right is laid down in Article 16 and 40 of the Convention. And according to the committee, as mentioned by the previous speakers, this requires that hearings of children are held behind closed doors. The verdict should be public, but the child should not be identifiable, and court files and criminal records should remain confidential. The Dutch youth justice system largely complies with these recommendations, but this is different in many other countries, including the UK and the US, where children are sometimes tried in open court and names and records of children are published online. Still, from a children's rights perspective, the importance of safeguarding the child's privacy throughout the procedure and beyond is vital. A hearing behind closed doors protects the child from the intimidating setting of a public trial. This is important to create an environment in which the child can effectively participate. Furthermore, protection of the child's privacy prevents stigmatization of the child, which is important to enable the child to reintegrate into society. With this, we reach the fourth and final pillar, the reintegration objective of youth justice. And it was also mentioned in the previous talk that according to Article 40, paragraph 1, the overall objectives of youth justice are to promote the child's sense of dignity and worth, to reinforce the child's respect for rights and freedoms of others, which includes prevention of reoffending, and ultimately to reintegrate the child into society, making him or her assume a constructive role in society. Reintegration being the overall objective of youth justice implies that excessive sentences should be avoided. So sentences that violate prohibitions of torture, capital punishment, life imprisonment, laid down in Article 37A, are incompatible with the reintegration objective. The reintegration objective also implies the deprivation of liberty, either pre-trial or as a sentence, should be used only as a measure of last resort and for the shortest appropriate period of time, since we know that deprivation of liberty is harmful for children's well-being and development. And if it's truly necessary that children are deprived of liberty, this should be done in child-appropriate facilities with trained staff and opportunities for education and leisure. The reintegration objective also entails that where possible, mechanisms to divert children away from the formal system should be in place to prevent children from the harms of going through the formal system. And I will zoom in on diversion in the final part of my talk. Moreover, also within the formal youth justice system itself, a range of non-custodial measures should be in place to avoid deprivation of liberty where possible. And this should include care, guidance, and supervision orders, probation, foster care, and educational and vocational training programs. And finally, the reintegration objective also ties in with the principle of proportionality laid down in Article 40, paragraph 4 of the Convention. And according to this principle, youth justice responses should not only be proportionate to the seriousness of the offense and the accountability of the child, but also to his or her personal circumstances and needs. Having heard all this, children's rights talk, one might wonder, but what about the interest of public safety? What about the interest of society? The committee in General Comment number 24 is very clear. Preserving public safety is a legitimate aim of youth justice. And the CRC does not completely prohibit deprivation of liberty of children. The committee acknowledges that deprivation of liberty can be acceptable if this is really necessary because of the risk for the safety or health of the public. Moreover, the committee states that when it comes to responses to serious offenses, measures should be imposed which are proportionate to the circumstances of the child and severity of the offense, including considerations of public safety and sanctioning. Yet, the approach should not be strictly punitive, because this would violate the standards and objectives laid down in Article 40. And ultimately, the children's rights approach to youth justice is built on the premise that public safety is also best served with a children's rights compliant youth justice system aimed at reintegration and aimed at making children assume a constructive role in society. And when it comes to practices that serve both the rights and interests of children and the interests of society, diversion is a promising area for youth justice reform. Article 40 under 3B of the CRC demands that states have diversion mechanisms in place as integral parts of their youth justice system. And the diversion refers to measures or mechanisms for referring children away from the formal justice or judicial system at any time prior to or during the relevant proceedings. According to the committee, diversion should be the preferred manner of dealing with children in a majority of cases because diversion has multiple advantages. Diversion prevents children from the potential harms caused by being exposed to formal justice proceedings. It prevents children from being stigmatized as criminals and from obtaining a criminal record. Diversion programs yield promising results in terms of prevention of reoffending, and also important, diversion is cost efficient. Diversion is usually a lot cheaper than formal case processing and sentencing, and this makes it possible to save the limited resources in the formal justice system for the most serious cases. Yet, the CRC also makes clear that when diversion is considered, the rights and legal safeguards of children should be fully respected. And as mentioned in the previous presentation as well, the committee defined various safeguards that should be upheld when diversion is used. According to the committee, as mentioned, diversion should only be used in cases where there's compelling evidence and where the child admits responsibility freely and voluntarily without pressure or intimidation. And the required admission of guilt imposes a tension with the privilege against self-incrimination, but is nevertheless an important safeguard against subjecting children who claim to be innocent to diversion programs without a fair trial. The admission of guilt may not be used against a child in any subsequent legal proceeding. Moreover, diversion should only be used by children when children give informed consent, which can be seen as a waiver of the formal trial. Furthermore, diversion should have a basis in the law, decisions should be regulated by law, reviewable, and actors should be properly trained. And the child is to be given the opportunity to seek legal or other appropriate assistance relating to diversion offered by the competent authorities. Importantly, diversion may not entail deprivation of liberty, and completing the diversion program should result in the definite and final closure of the case without a criminal record. And finally, despite all the advantages of diversion, it's important to emphasize that the right to a fair trial, including access to an independent and impartial court, remains a fundamental right of children who are accused of criminal offense. In other words, diversion should not be used to circumvent the child's fair trial rights. In this final part, I will provide two concrete examples of what I believe are promising diversion programs or approaches. A first one is the so-called HALT intervention from the Netherlands. And this intervention finds its roots in a local practitioner-driven pilot project in the city of Rotterdam in the 1980s, and is nowadays the main nationwide diversion program for children in conflict with the law. A HALT intervention is an educational project of maximum 20 hours, which can consist of community service, educational activities, and apologizing to the victim. The police or the prosecutor can refer cases to HALT, thereby avoiding formal prosecution. If the child successfully completes the HALT program, the case is closed and the child will not have a criminal record. Dutch law and policy provide several requirements that should be met before the case is eligible for a referral to HALT. First of all, HALT is primarily designed for first offenders who commit relatively minor offenses. Secondly, there should be compelling evidence and an admission of guilt and informed consent from the child. If the child is below the age of 16, informed consent by parents is also required. Moreover, under Dutch law and policy, all children suspected of a crime are entitled to free legal assistance. The HALT intervention makes up for roughly 50% of all youth criminal case dispositions where an intervention is imposed, which is in the Netherlands roughly 5,000 cases each year. So this is substantial. It means that the formal justice system is relieved from a substantial amount of cases and that the involved children did receive an intervention but were prevented from obtaining a criminal record. So when it comes to diverting cases away from the formal system, this looks rather effective. The overall effectiveness in terms of reoffending rates, however, is currently under review by an independent research team who deploy a large-scale randomized control trial, and results are expected in the coming years. A second and final example is a practice developed in Pierce County, that's near the city of Seattle in the United States. This example shows how diversion can have a significant positive impact on the youth justice system as a whole. I visited Pierce County Juvenile Court in the summer of 2022, and the reason why I was interested in visiting this county was the significant reduction of the youth remand population, from an average daily population of 163 children in pretrial custody in the year 2000 to an average daily population of 9 children in custody in 2021. And when I was visiting this county, there were 8 children in custody. Interestingly, the drop in custody rates went hand in hand with a reduction of child offending rates in Pierce County. And importantly, the significant drop in youth custody rates is largely the result of purposeful reform, practitioner-driven, locally organized, and collaborative, including key stakeholders such as the juvenile court, prosecution, probation, and community partners. In 2000, the Youth Custodial Center was vastly overcrowded, and the local stakeholders had to make a decision, either investing a lot of money in expanding the youth custodial institution or investing in alternative strategies to reduce the number of children in custody. The key stakeholders decided to choose the latter, supported by the Nyesom-Wike Foundation. Key strategies that they implemented are, firstly, the so-called raise the floor, raise the ceiling approach. The idea is that by expanding diversion for low and medium risk youth, which is raise the floor, caseloads of probation are reduced, meaning that probation workers have more time and resources to work with the more high-risk youth with complex needs. If probation staff can provide more intense supervision, this allows for more high-risk youth being potentially eligible for probation instead of placement in custody. This is raise the ceiling. As a result, only children who are charged with very serious violent offenses and who impose a threat to public safety that cannot be managed in the community end up in custody. A second part of the strategy is probation transformation. So changing the ways probation officers work with children they supervise. In the past, up to 1/3 of the youth custody population consisted of children who were detained because of so-called technical violations of probation, which means a violation of probation conditions without committing a new criminal offense. So, for example, not showing up for an appointment with a probation officer. In the past, these children would have often been sent to custody, but today, probation will seek alternative responses, which add to the drop in youth custody admissions. And finally, a third part of the strategy is systematic data collection, which enables the stakeholders to track progress in terms of detention admissions, diversion referrals, and reoffending rates. And the results of diversion look promising. As of December 2020, more than 80% of diverted youth had no new arrests 2 years after being diverted, and 93% had no felony arrest. Finally, what makes this example particularly interesting is that this significant reform is the result of a change in local court culture, policy, and practice. This has been achieved without any legislative changes, which in my view underscores the importance and the power of practitioners in youth justice reform. I come to a conclusion. In my talk, I have emphasized that a children's rights compliant youth justice system requires humane treatment of children, child-specific treatment of children, fair treatment, and treatment aimed at reintegration. And these core pillars are interrelated and should be merged into a comprehensive youth justice system. I've also highlighted diversion being a promising area of youth justice reform, potentially preventing harm to children and reducing reoffending. And ultimately, I would like to end with that, a children's rights compliant youth justice system based on humanity, fairness, and aimed at reintegration serves both the best interest of the child and society. Thank you for your attention.
Thank you, Dr. Yannick, for that insightful discussion. Thank you once again. Indeed, children differ fundamentally from adults, and we cannot overstate the importance of child-specific treatment. Thank you very much. And now we have come to the end of the second session. And it is at this point that we'll be taking questions as well. So please, if you have questions, you can put them down in the comment box, and we'll be taking the questions that have already been put there at this point. But please, if you have more questions, you can always put them down in the comment section. Thank you very much. So I'll be reading the questions out, and I believe any of our speakers can always provide expert response to that. Okay, so the first question says, "Good evening, Professor. Thanks a ton for the presentation. What kind of non-custodial sentence can be given to a 16-year-old boy found liable for defilement of a 5-year-old girl?" So I believe this question is for Professor Ogunniran. I'll read the question again. Please, what kind of non-custodial sentence can be given to a 16-year-old boy found liable for defilement of a 5-year-old girl? Thank you.
Thank you very much for that question. And I think it's one area of challenge that we have across the states, the country. This was, I remember a judge telling me recently that in his court, he has so many, children below the age of 18 years. It's a family court, sleeping with each other, that what should be done. And I think that in that instance, there is no hard and fast rule about it. There is need for a lot of counseling. There is need for a lot of counseling. And you may not really use a non-custodial disposition measures, depending on, the family and the weight of evidence. If the weight of evidence is very heavy, depending on the state, like the research that I just concluded now at the correctional centers in Lagos, some of them are in that center because of this sexual offense. And the aim is what? Is for treatment and training. So I would say that there is no hard and fast rule about it. What I can just say is that such children, they need counseling. Counseling should be more than, because we are talking about reintegration of the children into the society. So if there is evidence that he actually did that, they are both under 18 years, then what the court should do is probably depending, because we are talking about family conferencing, we are talking about using restorative justice, we're talking about using community service under supervision. But that doesn't mean that the custodial measures, they are not there. They are there, but the court must now use it with information. Maybe the child should just stay there for a year, and it will be for training, training and treatment in particular. Because the challenge that we have with custodial disposition measures is because most of the time, the facilities that you even need for the treatment of those children, they are not there. So at the end of the day, in some states, the children are even put in, prisons with hardened criminals. So at the end of the day, you don't really achieve anything. But you have to use a lot of discretion in that regard. Thank you.
Thank you very much, Professor. Thank you. Dr. Yannick, I don't know if you have any contribution to that as well, or if we can proceed to the next question.
Yeah, no, I fully agree. That would also be approach in the Netherlands, aimed at treatment, and depending on how high the risk of reoffending is, whether it should be treatment in a closed facility, or whether it can be treatment in the community. So yeah, I agree.
Thank you very much. I believe that question has been answered. Thank you to our speakers once again for the insightful presentations and response to these questions. Thank you. So taking the second question, it's a bit lengthy, but it's straightforward anyway. So, and the question says, Section 149 to 162 of the Child Rights Act of Nigeria provides for the family court to be presided by the magistrate court and high court respectively, as the case may be. The court, that is family court, has unlimited jurisdiction to entertain civil and criminal proceedings involving children. While Section 277 of the Constitution of the Federal Republic of Nigeria established Sharia Court of Appeal, whose jurisdiction is to entertain Islamic personal law relating to marriage, divorce, inheritance, custody, and guardianship of a child. And the question says, don't you think that there is a conflict between the Constitution and the Child Rights Act? If there is a conflict, how do you think the conflict can be resolved? So I believe this participant's question is in terms of the Constitution and the Child Rights Act. So I don't know if...
Yes, thank you very much for that question. I think we did a research, sometimes that was published in 2016, and we interviewed some judges, and they were even talking about the contradiction between the composition, of the court and the constitution, that the High Court is properly constituted once you have a judge. But the Child Rights Act is saying that there should be a judge and then 2 assessors. But my own position to that is that I think there's an amendment going on the Child Rights Act and even the Child Rights Law. So that amendment must take care of this, because the Child Rights Act says that the family court has exclusive jurisdiction, to matters relating to children. So there is need for harmonization. There is need for harmonization, not only with the Sharia Court of Appeal, but even the composition of the State High Court, which is properly constituted under the Constitution if you just have a judge. But maybe these are some of the things that we should point out, when we are meeting. Because, and another thing we should know is that now that we have courts, we have states adopting the Child Rights Law, adopting the Child Rights Act. The Child Rights Act was enacted for Abuja because of the Sharia and customary views, those who are using Sharia law and customs, child marriage, Sharia courts, So it was enacted for FICMC, then other states started to adopt. So if you even look at it today, you will see that in the north, you still have Sharia courts, and Sharia courts have Sharia judges with the training and everything. Meanwhile, it says that the family court should have a judge. So there are areas of contradictions, I know, but maybe when we have our meetings, or if you are part of a review committee, these are some of the things that we should point out.
Thank you.
Yes.
Professor Iyabode. Thank you very much for that insightful response. And I believe it even relates to part of your presentation as well on with regards legislation. Okay, I think we have one more question here that says, how do you deter children from defiling fellow or younger children if there is no punishment? Shouldn't the 5-year-old get justice? So I believe this is a follow-up from the first question that was asked. Thank you.
Thank you very much. Like we have said, if you look at the Child Rights Act, there is provision for custodial measures, but we still have to exercise caution in using it. If you look at many of the states, they don't really have child-specific or specialized centers. And if you must put this child offender in the correctional center, it must be for the purpose of treatment and training. So you really have to look at that. Of course, if I'm a judge sitting in that case, that kind of a child will go normally to a correctional center. For the purpose of what? Training and treatment. But if there is no treatment, I'm talking about treatment in terms of counseling, I'm talking about treatment in terms of vocational training, I'm talking about education. So if those things are not going to be there, then that child will go to that center. If you have a state that you don't even have a center, then you have to exercise caution, because most of the time when you send these children to remand or approved institution, they don't come out better. So there are so many things to weigh, and that is why we're talking about the best interest of the child. Are we going to weigh the best interest and weigh the safety of the society? The best interest of the child, we weigh the welfare of the child and the justice to the society. So it's a new area. There are new things developing that we still need to think through and be able to fit into this justice system. Because justice to the 5-year-old is not sending the 10-year-old to the prison unless there is a correctional center, just like the name signifies, correctional center, to correct that child. If that is not there, then I think a midway approach would be okay.
Thank you very much, Professor. Dr. Yannick, I also don't know if you have a few points to add to.
Yeah, I think that's in line with the professor. I think it's very important to distinguish justice for victims from retribution. Because first of all, retribution requires accountability, which is diminished for children anyway, and especially children who commit offenses like this are often also, well, disturbed in their development, so therefore in need of treatment. So that also diminishes, well, the accountability needed to be very retributive, I would argue. And then the justice for victims is, of course, very important, but I think it's also important to seek alternative ways of compensation or assistance, or, well, in the Dutch system, financial compensation would be one thing to impose next to treatment of the offender, but also other support mechanisms for victims, to have those in place as well. I would add.
Thank you, Dr. Yannick. Okay, I'll quickly run through a few more questions with the kind permission of all participants present. We just have a few more. Another question says, in addition, in addressing the contradiction between cultural practices and legal standards in Nigeria, how can the legal system effectively protect children involved in early child marriage, balancing respect for cultural traditions with the enforcement of children's rights as per international and national laws? I don't know if we got the question, or if I should, maybe I'll just reiterate.
No, don't worry.
Okay,
the person is talking about child marriage.
yes, ma'am.
Child marriage is another area entirely where you have challenges because of our cultural system, the religion and the culture, especially in some particular parts of the country. And you have, I don't think, for me, what we can do, Anahim suggested, and I align with him, that what we can do is to, try to educate people, so that, because it's their culture, it's part of them. So anytime I want to talk to people about changes in child marriage, I will go from the social, medical perspective, talking about the fact that some of these children, what they go through, the VVF, some of them, if they have children so early, what will happen to them medically, So you have to sell the idea, and it will take time for you to educate them, for them to see the reason why they should change their culture. But if you are going from the angle of confrontation, you will never make headway, because they will always. So the thing about child marriage is that we have to engage, the stakeholders in those communities, in those areas, and tell them, coming from the socio-medical perspective, and hoping that with time they will agree. If not, there is nothing you can do about it. The law can be there, but they will just continue to breach. In fact, that's one of the reasons why many states in the north, the Sharia implementing states, why they did not adopt the Child Rights Act. It was because of this major reason, child marriage. So you have to sell it to them. In fact, I did a research at that time. Borno State and one other state like that had a child rights bill. They removed, in that section on child marriage, they said, for the purpose of this section, a child is not somebody under 18 years. They removed the age from that section. So we have to be selling it to them, continue to engage them, continue to advocate, and that's the only way.
I'm just wondering if I can make some contributions. Chisom.
Yes, my lord, please.
Okay. Excuse me. As regards the earlier question concerning the 5-year-old and the 16-year-old, in agreement with both speakers, punishing that child, that is 16 years old, really does nothing for the 5-year-old. In other words, if that 16-year-old is sent into custodial protection or just remanded, it will not undo that act that a child had committed on the 5-year-old. It's just like when somebody loses a person and somebody else is held as responsible for causing the death of that person. No matter if the judge pronounces a conviction of death by hanging or any other method, it will never bring back the person who is now dead, back to life. So there's really nothing to gain there. The deed has been done. And you can imagine there have been cases where this kind of scenarios come up, and in future, those children might turn out to be friends. It is not the best way to start friendships, yes, but even the families sometimes are encouraged to make friends with the other family. And if that 5-year-old child, is compensated in the way that makes sense to their parent or the child's parent, it might be better off for that child than for the child to go with nothing but a conviction, or not conviction, because of course the child cannot be convicted, like custodial punishment. There are other methods that the child can be punished, like the first speaker had said, the Professor Iyabode, Ogunniran. She mentioned community, how will I say, punishment or engagement, in the sense that the child can go and do community work that would benefit any community that he's sent to work in. It could be sweeping or just cutting grass or something, but that will put that child in a position where he realizes that he has done something wrong and this is the punishment that he's getting. And I want to believe that that will go a long way to make him understand that that deed should not be repeated. The child can also be supervised by an officer, somebody who will go and check on him every once in a while, make sure he comes around. And these persons who work at the social welfare ministries are even enjoined to help them, advise them, make friends with them, and teach them so that they can be better citizens. And, especially if they are remorseful, it's easy for them to, get into recognizance in the court to ensure that they will not, commit that offense anymore. The important thing is for the child to be made known or just to be on to be made to understand that they have done something wrong, and that the child, realizes that, and in that realization is determined not to go back there. Just like Professor Ogunniran said, going into those custodial environments sometimes makes them worse, and they don't come out any better. So if you now allow that child to be exposed to that, what are you doing to society? When it comes out even more hardened and is determined to, do much more harm to people who are around them. So sometimes it's good to just, that's what the whole essence of diversion is about. Talk to the parties, their parents, and try to see how you can reconcile them as best as you can. The child can also be made to pay a fine. There are different other ways that you can, punish that child without putting that child in custody. And of course, there's just so much you can do with the law, as far as punishment is concerned. And the thing is to make the best of the situation, as bad as it may be. As regards child marriage, I want to say that the conversation has started, in Nigeria presently with the Ministry of Women Affairs. They called dialogue, a national dialogue, talking about child marriages in some of the states in the north. I happen to have attended that conversation or that activity, and I was very impressed with the responses from the panelists that spoke. All of them from the north, most of them were and then there was a sheikh and an imam, and then all their responses were really positive and very encouraging, so that I could see that in the not so distant future things will be better for the young girls, especially in the north where this occurs. It's sad that it does happen. Apart from the medical aspect that Professor Ogunniran has spoken to, there is also the economic perspective of this. Imagine a very young girl marrying a very old man. What happens? Just as nature would have it, the old will always predecease the young in normal circumstances. So when the time comes and this man dies, the child that has been married at the time she was a child may still be a child when the man dies, or may not be much more above the 18 years mark. So this child has children who are children, of course, and she's still a child. What does that do? How does it affect us socially? She can't even really take care of herself, much less take care of another child. And that's why the cycle of poverty, just continues and is sometimes sustained in places where this really occurs, because the woman now falls into a position where she starts suffering because maybe she hasn't had a good education, and that's the whole essence of delaying marriage, so that the girl can go to school. And with an education, there's so much more you can do for yourself and be of better use to yourself, your family, the society, as opposed to when you don't go to school and you get married, and then God forbid it happens that a man, even if he may be wealthy, leaves you with children that you cannot cater to. So it just encourages the cycle of poverty, and then it puts the woman or the child wife in a difficult position, looking after those children. Of course, it's something that should be encouraged. There's so many detriments that come with the child marrying at being a child. She cannot really she doesn't even really understand most times what she's going into, and the best really doesn't come out from that situation, is what I'm trying to say. And is something really that should stop. Those elders from the north and royal fathers, they were very clear when they said that if you come into a community, and of course you come in not as a member of the community and you're speaking to people, they'll just watch you. And when you finish, they let you go and they continue with what they will do. So you need to have them buy into what you're saying. They need to understand you, accept what explanation and the reasons that you're giving for discouraging this practice, as well as other practices, of course, all over Nigeria. And when they do understand, they can now articulate it to their people who listen to them and who defer to them. When they hear them and they understand, they will listen to them, and then in time, this will stop. And I think we're getting there. Excuse me. So I want to believe that it's going to get better. And in no too distant future, I'm believing and hoping that this talk about child marriage will be put to rest. Thank you.
Thank you, my Lord, the President of the NAFCJMP, and to our respected speakers for today for the enlightening and instructive presentations. Thank you very much. Indeed, time is fast spent, and in as much as we would have loved to continue, we have to go on to the next item on the agenda. Just in closing, and may I humbly invite for the closing remarks the General Secretary of the Association, Honorable Justice Elizabeth Ibrahim Angai, to take the closing remarks. Thank you. You are most welcome, ma'am. Okay, whilst the General Secretary is working on her microphone briefly to come up, I could just mention a comment that was also stated here, although we have many more comments, but there's also one here that says, can we also look at the challenges of child widows who are oppressed by older co-wives and stepchildren? Okay, ma. Okay. And now we make welcome once again.
Hello?
Yes, ma. You're welcome.
Okay, thank you so much. First and foremost, I would like to express my appreciation to the guest speakers for a comprehensive presentation on the protection and participation of children in the justice system. The webinar has exposed participants to the following lessons that we have learned, and which is exposing us to international legal frameworks on the rights of children, the family court, heals and listens to children's plight in the event they come in conflict with the law. The child justice system is different from the normal adult justice system. Hence, it is guided by specialized procedures. Children in conflict with the law are human beings, and so they should be treated humanely. Punishments are reformative, and they reintegrate children that come into conflict with the law back into the society. And then we also learned about the alternatives to custodial sentencing. Lessons we have learned will help participants and practitioners in observing best practices in the protection and participation of children in the justice system. And therefore, the cause of the best interest of the child as envisaged in the child rights laws in the country. Your active participation through listening, questions, and answers provide a very good opportunity to learn more from our experiences about the best practice to be observed in protecting the children. My greatest appreciation goes to our guest speakers who made the webinar very captivating. I want to also extend my deepest gratitude to all that sacrificed their precious time to be part of this meeting. Your attendance made it very successful, being a maiden edition of the prestigious association's webinar. We are indeed blessed by the various issues discussed and lessons learned, as they will go a long way in adding value to our work and addressing the challenges we often encounter in the course of discharging our duties as judges, assessors, and practitioners in family courts. I'm sure we are departing fully equipped for the tasks ahead of carrying out our different responsibilities in the protection of the rights of children and in their best interest. Thank you all for attending. Looking forward to meeting again at subsequent meetings. God bless us all.
Thank you, my Lord. Honorable Justice Elizabeth Ibrahim Angai. Thank you for the closing remarks. And may we make welcome the presidents of the association for the vote of thanks and charge. You're most welcome, my Lord.
Okay, thank you, Chisom. I want to thank our Secretary General for that very succinct and impactful closing remarks. And I will especially want to thank both our speakers, Professor Iyabode Ogunniran and Dr. Yannick van der Brink. And I'm hoping that when we call you again, you will be obliging us. Thank you for your impactful lectures that I'm sure will go a long way to prepare us even better for our duties ahead. I wish we could really clap for them, give you some really loud applause, but I don't know, it seems like that doesn't happen in webinars. But thank you. We do appreciate you. We're very grateful that you turned up, and especially participants, because without you being here, we will not have had the webinar. As has been mentioned, this is our maiden outing, and we intend to hold these webinars at least every once in a quarter, every 3 months. And the whole essence is because, they're cheaper to engage in than when you compare them to seminars or conferences, when you have to fly yourself maybe to a destination, book a hotel, pay for transportation within, feeding and all of that. convenient way, and then we can have maybe our annual debate, and we're in the process of making our constitution. So I'd like to announce to the members and the intending members that if you have any contributions that you can make to make our constitutions the best, please go ahead and do so. Intending member and a conference from last year, October, and that is also available. I'm hoping that you know, when this review, well, the review for Child's Rights Act has actually started. We do have a member, you know, who is in that committee as a consultant, and I want to encourage all of us. Like we have noticed, there's some naughty areas in this Child Rights Act, and you know, when we have been going about our practice, we've noticed where we can make on our WhatsApp platform. Law is there, you know, it's better, which is why it is being reviewed, you know, but even as it is now, they have provisions for research, for analysis and all of that. So like check to see why children committing more crimes. Why is this particular crime more prevalent than it was in times past? You know, what can we do to make children more engaged, you know, to keep them away from finding time to go in conflict with the law? There's a lot of, you know, beauty in this particular legislation. I love it so much. And I wish we could find ways to implement it. I want to think that the whole idea of this association is to act as a catalyst, you know, to, you know, bring people that matter, stakeholders, you know, to come, be on their feet and do what it is that is expected or required of them. Talk about the implementation committee on the on all the three levels of government: federal, state, and local government. I wonder how many states are actually engaging that committee. Is it effective? Has it been inaugurated? Is it working? You know, what have they achieved? If, you know, it is there and it's, you know, in existence. If we have those committees working on all levels of government and in all the states, you can imagine the difference it will make. Think about the beauty that it will be to see a family court in every local government area in this our country, Nigeria, so that people, you know, have access to justice. Justice is brought closer to them, as opposed to traveling long distances to go to just one family court that is in one particular local government, maybe the capital in a state. So there's a lot that should be done. You know, we should bring to the attention of those in government and even those outside government what they can do to make it better, to implement this law in a way that it will be beneficial for our child or our children. So we just look at ourselves, I want to say, as an association that will catalyze the situation and make it, you know, everyone. I mean, corporate social responsibilities, you know, it's expected from the corporate organizations that operate in different places, you know, in Nigeria. They can come together to decide to build a family court. Some states don't have family court, and that is such a shame. Not even one anywhere. So they use their regular courts, which should not be. The family court should be separate from the regular courts, you know, because it should be a place that is relaxing for the child, so that the child can participate in the process, not being tense from the normal court, you know, system. So there's a lot to be done, a whole lot to be done. People can come together and decide to build a family court if they're encouraged, and why not? You know, we don't intend to engage with anything that has to do with monies. We'd rather have these people use their monies to build, we give them a prototype, and then they can build to specification so that it can be a building conducive for the use as a family court, or even one of those child centers, and there's so many of them that we should have. Some can do the work of 2 or 3 functions that 2 or 3 can do, but some states don't have these facilities. And how do you really help the process of child justice system if you don't have those facilities? So we intend to do our best to make sure that we'll bring to bear our existence to people who matter, and we all do matter, so that we can all together make it better for the Nigerian child. To our judges, magistrates, assessors, councillors, court staff, state council, prosecutors, legal representatives, and all lovers of Nigerian children, I implore all of you to render your service, realizing that it is service unto God who watches us all. We must therefore be patient, diligent. We should be gracious and kind, gentle in handling the child at all times with respect. Note that they are persons, they may be miniature, but they are persons themselves and holders of rights, and they do deserve our respect. We should also note also that it is what you give to the child that he or she gives back to society. We must never forget that, and know that in giving out our service, we should do it in a way that is gracious and kind. It's only in a matter of time, for anything you put in the child to manifest. As such, we should just give them a good experience to recall in their latter years, so that they too, becoming mothers and fathers of tomorrow, leaders of tomorrow, they will impact, their children positively and impute in them much more than they had the opportunity to get. And our children should keep getting better. I keep saying that the hallmark of successful parenting is that our children are more successful and better than we could ever hope to be now. They should be better. So let us all do our work with the utmost, within our utmost best, energies, or how will I say, our powers. Whatever it is we can do, we should give it our best, so that our minds are rested, knowing that we have done and given our best. Thank you so much again, every one of us that have remained to the end, and even those who have left. I pray that God will continue to bless you all and your families. And so I say keep well, and as I always say, stay beautiful. Thank you very much. Chisom, back to you.
Thank you, my Lord, the President of NAFCJMP. And now we have come to the end of this maiden webinar. Thank you all. The recording is also available for playback on YouTube, as some persons also joined us on YouTube live. Please follow the association on Facebook, on X, and also Instagram for more information on public events organized by the association, and also relevant information that will be shared by the association. And for further inquiries, you can always send an email to nafcjmp@gmail.com, including your response to the call for contribution made by the President in her charge. Thank you, and do have a pleasant evening.